Good morning and welcome to the BBA's webinar channel, where we discuss the latest issues impacting and affecting banks and regulated firms alongside subject matter experts in their field. My name is Philip Allen. I'm the Director of Learning at the BBA, and today for the next hour to discuss our senior managers regime, what to do when the regulator comes knocking, I am delighted to be joined this hour by Francis Keane, Executive Director at Willis Towers Watson, and Peter Bibby, Partner at Brown Rudnick. Just before I hand over to Francis, you can participate in this webinar in two ways. Number one, by asking questions. If you have a question for the presenters, you can ask a question at any time simply by clicking on the Ask a Question button on your screen, which is located underneath the presentation. Please note that when you ask a question, your name and your organisation is not disclosed to any other webinar attendees. Number two, we also like you to participate in our Ask the Audience polls. To participate is simply a pop-up box will appear on your screen. Simply answer the question in the box and click OK. We will make sure that the slides are socialised after the webinar, and the presenters have very kindly offered to stay to answer any questions that you may have post the webinar. We intend to present for 40 minutes and then answer your questions for the remaining 20 minutes. Francis, over to you.
Thank you, Phil, and morning, everyone. We're going to turn to the first slide, which will serve as a reminder, I hope, of the ground that we're going to cover this morning. And whilst you are reminding yourselves of those various bullet points, I'd just like to give you a bit of context here. Among the many different eras in which we currently live is the era of personal accountability. And there are plenty of quotes to make good that fact. Andrew Tyree, who's still very active in this industry, as you know, when he served as chairman of the Parliamentary Commission on Banking Standards, said a lack of personal responsibility has been commonplace throughout the banking industry. Senior figures have continued to shelter behind an accountability firewall. Many junior staff who may have done nothing wrong have been impugned by the actions of their seniors. This has to end. This era of personal accountability is not limited here to the UK. The Sally Yates memorandum, the US Deputy Attorney General on deferred prosecution agreements and the need to make available senior employees to prosecutors in suitable cases, is also an example of that. She said, corporations can only commit crimes through flesh and blood people. It's only fair that the people who are responsible for committing those crimes be held accountable. The public needs to have confidence that there is one system of justice, and it applies equally regardless of whether that crime occurs on a street corner or in a boardroom. Now, the mood on the street isn't particularly forgiving in a more general sense. I was struck, whatever your views on Brexit might be, by the Daily Mail headline under photographs of the Lord Chief Justice and two other High Court judges following the Brexit ruling, saying enemies of the people. Now, should we be worried about all this in the context of the senior manager regime? After all, there are some fairly comforting and emollient words coming out of Andrew Bailey and his predecessor, Tracy McDermott, as to the way in which this regime will be applied. And it's also true to say that there haven't been any enforcement actions, at least of which I'm aware, post-senior manager's regime coming into force in February of this year. I think the way I would put this is that none of what Peter and I are now going to be saying to you and discussing matters unless you're unlucky enough to find yourself in a situation where there is a problem. The point is that if, when that does happen, all you know is the mechanics of the senior manager's regime and the certification regime, it may be too late for you. What we feel you need to know is how and why the new regulatory focus on personal accountability has affected, firstly, the nature of your relationship with your employer, or has the potential to do so, and secondly, your ability to avoid censure and penalties. So, in short, be prepared, or perhaps rather more amusingly, as it was put to me by an ex-FCA enforcement officer recently, he told me the story of two hunters who were in a forest by a campfire, and suddenly a bear starts charging towards them in the undergrowth. And as they get up to run, one of them puts on his running shoes and the other one turns to him and says, why are you putting on your running shoes? Surely the bear can run faster than either of us. And the one who's putting on his shoes says, well, yes, you're right, but I don't need to run faster than the bear. I just need to run faster than you. So, Phil, with that said, perhaps I could invite you to ask the audience a couple of questions.
Yeah, thank you for that. So a couple of questions are going to pop up on your screen shortly. Okay, on a scale of 1 to 5, 1 being not confident at all and 5 very confident, how confident are you that you understand the different grounds on which enforcement action could be taken against you? Just wait a few seconds for people to answer that and we'll just publish the results shortly. Okay. Question number 2. On a scale of 1 to 5, how confident are you that you understand the trigger points for the insurance and indemnity protections which you enjoy? And again, we'll just wait a couple of seconds for that to come up. Okay. Very interesting. Thank you very much for that. Peter, over to you.
Thank you very much, Phil. Okay, what I would like to do, because I think it's always helpful in these circumstances, is to go a little bit back to first principles and to look at the purpose of enforcement, because in order to understand how likely it is that any action may be taken against you, it's very important to understand what the regulator is trying to achieve through enforcement. And, you know, the main purpose is to help the regulator achieve its statutory objectives. And we all know that those are consumer protection, enhancing market integrity, promoting competition. FCA resources are limited, and they do not have the ability to be able to police all firms all the time to ensure compliance and an approach which is consistent with those objectives. So therefore, they need to use their resources in a smart way. The role of enforcement is a high cost and high profile regulatory tool. It's a regulatory tool amongst the broader regulatory toolkit which the FCA can use to achieve its statutory objectives. And when you look at it like that, you begin to realise that what we're talking about here is not a system where the primary purpose is to punish, although that is important where there has been serious wrongdoing. It's a system where the primary purpose of enforcement is to influence behaviour. And the influencing of behaviour takes place at two separate levels. Firstly, at the level of the institution that is subject to the action. Now, that will occur if you have a particularly large institution where the regulator believes that it's necessary to take action to ensure that that institution is going to change the way that it behaves. Secondly, and probably much more importantly, it's to influence behaviour more generally across the industry. And if you think about it, given the cost of enforcement, where the FCA invests that cost, then it's looking for a real tangible change in return. And the question which the regulators have struggled with since statutory regulation came in is, how do you achieve that second aim? And the problem that they have faced is that the approach that they've taken historically
has not necessarily brought that change about. And the jury which considered this issue was essentially the Parliamentary Commission on Banking Standards, and it raked over the history of regulatory failings over the past 10 years. And these included PPI, LIBOR, Forex, and the culture that allegedly led to the financial crash. And the verdict of the Parliamentary Commission was quite clearly that the FSA's approach to regulation, and more particularly enforcement, had not been successful. It had failed to change the culture of organisations in general. Penalties were increasing against firms, hitting shareholders, junior people were being held to account for their personal failings, but nothing was changing. And there was a risk, and I think there was a very real risk, that those who were making decisions at the top of institutions were seeing enforcement as a cost of doing business. And the conclusion, as far as the PCBS was concerned, was that the approach was failing because nobody was being held to account at the top of organisations. And the PCBS raised this with the FSA. And the FSA identified the difficulties that existed with holding senior managers to account. The difficulty of identifying who was responsible for what when boards took decisions collectively. Everybody was pointing at everybody else. They've tried to take action against senior managers, but it had been very difficult to succeed at the tribunal. The tribunal was applying a set of criteria to those cases, which made it difficult for the FCA, particularly where there was no evidence of bad faith or bad behaviour. They pointed out also that there was no incentive for people to settle, given that an adverse finding would likely end their career. And this meant that cases were difficult and hard fought. And absent an outcome, the FSA was required to keep matters confidential. So they weren't even in a position to be able to explain to the wider world that they were taking action. So the upshot of this was that the Parliamentary Commission on Banking Standards were behind changes to the legislation. And the changes to the legislation were designed to bring in a new regime to sit alongside and in time to replace the existing approved persons regime. The new regime, senior managers regime and the certified persons regime, would firstly reduce the responsibility of the regulator to pre-approve staff by focusing on the individuals who are really in charge at the top of an organisation. It would place the onus far more on a firm to satisfy itself about the ongoing fitness and properness of its staff who are in positions of influence or who are dealing with customers. It would require firms to be clear about who was responsible for what, and it would require those who were responsible to sign up to that responsibility. It would introduce conduct rules for individuals, differentiating between senior managers and others, and it would extend the grounds on which a senior manager could be held liable for misconduct. And in order to ensure that the regulator had sufficient time to be able to make good on those new powers, it would extend the limitation period for action for misconduct to be taken against an individual to 6 years from the date on which FCA became aware of the fact. So, that is the background. And then the question which we have is, how can a senior manager be held responsible? And there are 3 grounds on which a senior manager can be held responsible. The first 2, failure to comply with a COCON rule, which are the new conduct rules, and knowingly concerned in a breach of a requirement imposed on the firm, are the same for senior managers and all other staff working in a relevant authorised institution, a bank, and this will subsequently be rolled out more broadly. But if you're a senior manager, you can also be held liable under the duty of responsibility. And that is a breach by the firm and a failure by a senior manager to take such steps as a person in the senior manager's position could reasonably be expected to take to avoid the contravention occurring or continuing. And many of you will be aware that this wording is a watering down of the original wording. The original wording was to bring in what was called a presumption of responsibility. And that was going to controversially reverse the burden of proof. And it was going to start from the premise that a senior manager was guilty of misconduct where there had been a failure by the firm in an area for which he was responsible, unless he could show that he had taken such steps as could reasonably be expected of such a senior manager. This was subsequently amended to read as it does today, and so to place the burden on the regulator to show that the senior manager did not take the steps as could reasonably be expected. But I think we have to take account of the fact that the regulator will see this as a strong addition to its armoury. And there are significant overlaps between the failure to comply with the COCON rule, but there are also important differences. And it is absolutely the case that there have been no actions taken under the duty of responsibility, so it's difficult to see how it will work in practice. But the FCA has issued a consultation on how the decision-making manual will be amended to take account for its introduction. And the guidance makes clear that the starting point for the question of what a senior manager is responsible for will be his statement of responsibilities. So to the extent that you sign up to that, it is going to be extremely difficult to then say, but in reality, it wasn't me. And if you want to say that it's not accurate, and you want to say that it wasn't you, then you're going to have to bring very clear and cogent evidence forward to convince the regulator. And even if you do convince the regulator, the question that the regulator is going to ask is, why in the first place did you sign up to it, if you're a senior manager? And why did you not, when you realised that you were not responsible for it, raise it with us as the regulator under your separate reporting obligation under Senior Conduct Rule 4. So, I think the point to take from that is that pointing at everybody else when something goes wrong is no longer going to be a realistic approach. The guidance also sets out a whole host of matters that will be taken into account when assessing whether the senior manager has taken such steps as reasonably could be expected, and lists those, including what to do when you become aware of a problem, and how to respond to a problem, and whether you took reasonable steps. Now, as people will be aware, the leading case in relation to taking reasonable steps was the Pottage case. And the Pottage case, which was decided by the tribunal, said that a senior manager will not be liable for misconduct if he can show that the steps that he took were within the bounds of reasonableness. Now, that is fine, and that is within the bounds of reasonableness at the time that that occurred. I think the Pottage case probably goes back to around 2010. Since that time, we have gone through a massive change in regulation. We have seen the regulator being clear that the focus is on individuals. We have seen the regulator being clear that these approaches historically will no longer be acceptable. And therefore, what one must ask oneself is, what are these reasonable steps in this new reality? And is it possible to say, for instance, I had an awful lot on my plate and I was prioritising the things that I needed to look at. But according to the FCA's recent consultation, that will not be a matter that is taken into account. So people need to be aware that taking comfort from the approach of the tribunal in Pottage may no longer be as reasonable approach as it used to be. To make matters worse, even if you are not having action taken against you for misconduct within that 6-year limitation period, action can also still be taken by the regulator to impose a prohibition. And that can be done at any time after the event. And that can be done on the basis that a person is not fit and proper by reason of honesty, integrity, competence, and capability. And it always used to be the case that people viewed that as being a purely protective measure. So effectively what happened was, if the regulator could show that somebody was a risk going forward, then they could be prohibited. The FCA had been clear in its new referral criteria that they believe that the prohibition tool has a purpose as a penal tool. And I think that is quite a significant change on the part of the regulator. So the point to take from that is, even if 6 years has passed, you still may be in the firing line. And what does that mean? That means that if you do get in the firing line, everybody is viewing things with the benefit of hindsight. So, moving on to what I think is an interesting area, and this is to look at the different phases of regulatory relationship for a senior manager. And what I've tried to do here is to draw a distinction between the steady state and when an issue arises. The steady state, as I see it, is, the position that everybody is in most of the time when they are managing their business, when they are carrying out their functions, carrying out their obligations. What they need to do is they need to have clear lines of responsibility. They need to be clear that delegation is appropriate. They need to have appropriate structures. They need to have proper oversight of what is happening. And to be honest, I imagine that most people have got lots of processes in place as a result of the senior management regime coming in. If a problem never occurs, will you be held liable? Well, the answer to that is no, because you will not come under the spotlight of the regulator. You will not be looked at carefully. You will be able to continue regardless. But how do you know that a problem is not going to occur? Well, quite clearly what you do in the steady state is to put in place proper systems, controls, procedures. But at some point, an issue may come up. And addressing an issue is where things change, because this is actually the point at which the duty of responsibility clicks in. And the duty of responsibility clicks in because you think there might be a problem. You think there might be a regulatory breach by the firm. And then you can be liable if you have failed to take reasonable steps to prevent that breach from occurring, or, and I would suggest more importantly, you failed to take reasonable steps to stop it continuing.
Peter, can I invite you to try and think of a practical example where that may happen? Let's take a situation perhaps where the FCA writes to a head of business unit and says, we've seen a certain practice elsewhere in the industry, and we want to receive your reassurance, Mr. Head of Business Unit, that this particular practice doesn't go on in your institution. How should a senior manager in receipt of such a communication deal with it?
I think I would suggest that is steady state. I would suggest that is a situation where there's no current view that you as a firm have a problem there. You are carrying on your regulatory obligations. You have people who report to you. You know who the relevant people are. Your first step, of course, should be to satisfy yourself that that problem does not exist within your business and that you have the necessary systems, controls, processes. And to the extent that you can satisfy yourself that that is the case, then absolutely fine. You respond to the regulator and you tell them that that is fine, and there is no need for the regulator to be concerned.
So let's just play that forward and break it down a little bit more. So let's say you do what you should do in the steady state, which is, you point out, is to commission some internal investigation just to ensure that there isn't an issue here. Let's assume, two questions. Firstly, when even you're doing that, when you're entirely ignorant of the situation on the ground in your institution, do you involve anyone else in the organisation? Do you involve the General Counsel, for example, at that stage? And second question, let's assume that after your preliminary research has come back to you, you see that there is the potential for some further research at a minimum being necessary, or indeed a problem surfacing. At that stage, would you contact the GC, and if so, to what effect?
Well, I imagine on the first point that most firms will have in place a system where significant communications from the regulator will be shared with appropriate people. So obviously you need to have full transparency and people need to know what the regulator is interested in. Having said that, the effect of the senior manager's regime is that by sending that document in accordance with your internal procedures to somebody else, you do not, as the senior manager, lose responsibility for that. Your responsibility remains. It is a letter which is addressed to you, and whilst other people will be aware of it, you need to take appropriate steps to satisfy yourself that things are okay. And at that point, I think what you would do initially is to do an appropriate assessment of the information within your business area. The difficulty that you have is if you start to identify that there may be an issue. And if you start to identify that there may be an issue, then the question I think I would be asking now if I was a senior manager today would be, do I have sufficient expertise myself? Do I have sufficient understanding to be able to carry out the analysis of that issue and reach a conclusion as to what should be done myself without involving other people within the business?
All right, so let's just continue the role play a bit. You assume you're the senior manager, and I'll assume for this purpose that I'm the GC, and either at the initial stage or after you've done your initial research, you do come to me and you say, well, I have got this letter, as you well know, Mr. GC, and this is the result of preliminary research. If I'm the GC, I may want to think quite carefully about what the implications of that are for my company, and indeed to consider what further research needs to be commissioned, and indeed whether such research needs to attract the cloak of legal professional privilege. And so I might well be thinking as the GC, well, I need to have some clear and direct involvement in this process now, and diplomatically or otherwise, I make that view quite clear to you, Peter, as the senior manager. So what should be going through your mind as I, the GC, and telling you that thank you very much for alerting me to the fact that the SEA has written this letter, but now I need to be very intimately involved with where we go from here?
I think what would be going through my mind would be that I would want to have the assistance of the GC. In fact, what I would want to have is the assistance of those people who have the necessary skills to be able to actually understand the size of this problem. But what would also be going through my mind, and I would want to do that because that is in the interest of the company, and obviously I have my duties to the company as a senior manager, but what would also be going through my mind would be the question of my own individual responsibilities to the regulator. Because I think what I am unable to do, I think quite clearly what I'm unable to do, is I'm unable to relieve myself of that responsibility by passing the matter off to somebody else. So whilst in a well-run, very well-organised firm, I would expect there to be, it's a little bit like a business continuity plan or a disaster recovery plan. I would expect there to be some processes and approaches which we would have agreed on in advance to how we will deal with an emerging issue. And that, I think, is a very good idea for all firms to be thinking. But what I would also know is that ultimately, because it's my business area, and because I've signed up to that statement of responsibility, and because I have my reporting obligations under COCON 4, I would know that I can't just leave it to other people to make those decisions. Decisions which they may be making, which could be influenced by, commercial considerations, or could be influenced by reputational concerns. Because those commercial considerations and those reputational concerns are not going to help me if I am stood in front of the regulator explaining why I did what I did. Because what I have to be sure about is that I have met and I have carried out my regulatory responsibilities. Now, what that doesn't mean is that I shut up shop, and it doesn't mean that I am necessarily at odds with the company. But what it does mean is that I need to be thinking about, is the business doing the right thing? Am I satisfied about this? Am I comfortable with the way that they are behaving? And I think one of the things which is important to remember, and I think there's been a lot of, there might have been a lot of words spoken about senior managers regime which have lost sight of this, is that it's not down to me to do everything, but it is down to me to oversee that what is being done is correct. And therefore, bringing in experts, bringing in the GC, all of that, absolutely, I think that is the right thing to do. But remembering that at the end of the day, I am effectively the eyes and ears of the regulator in that situation.
And to discharge that duty of oversight, as you put it, you do need, do you not, to retain an element of controlling process alongside the GC and whoever else internally is managing the process?
Well, I think an element of control. I think what you need to be doing is ensuring that you are getting clear reports on what is happening. You are understanding the decisions that have been taken, and you are in a position, and this will be different for different senior managers, because some senior managers, I'm sure, will have the level of knowledge and expertise to be able to understand what the regulator would expect in this situation, but you are able to take an objective view about whether the company's response is an appropriate response. And the point that I would make there is that you need to, it's about identifying the issue, assessing the extent of the issue, stopping the problem if that is leading to problems for market integrity or consumer protection, reporting, addressing the consequences, understanding the root cause, and ensuring there is no repetition. And I think, one of the things that you need to be able to be thinking about is, how am I going to advocate and explain my actions to the regulator immediately post a report to the regulator? Long term, if you're unlucky enough to be caught in an investigation, how am I going to present my evidence to protect my position? And I think, just looking quickly at the likelihood of an investigation, the situation now that we have is that following the Green report into FSA decision making, following the Green report, the way that the FCA approaches these matters is to consider for each individual and each entity that may have met the statutory threshold for an investigation, and the statutory threshold is pretty low if it appears to a regulator that there are circumstances suggesting a person may be guilty of misconduct. And then once you've identified each person that meets that statutory threshold, to carry out a policy assessment as to whether there should be an investigation. And you can see that in that policy assessment, one of the points which is there is that for cases against senior individuals, would enforcement action deliver a strong message to senior individuals in the broader industry about the personal consequences of misconduct? So, given that that policy assessment will be being carried out, you want to be able to be in a position to explain to the regulator why actually investigating you and potentially taking action against you would not deliver a strong message to senior individuals, because you have acted properly.
So Peter, I'm just, while you're talking, I'm just looking at some of the questions that are being asked, and one that seems very opposite to what you've just been saying. And it asks, in the situation being discussed, where decisions are made by committees, not individuals, do you expect this to lead to more whistleblowing if the individual deems the outcome not appropriate?
I think the answer to that must be yes. Whether it's whistleblowing, because I think it's interesting to speculate on how this might work in practice. Because I would anticipate that if I'm a senior manager, then probably what I'm going to do is I'm going to be unhappy. If I'm unhappy with the way that something is being dealt with, then I am going to raise that first internally. And I'm going to say, this is not acceptable. And the response I'm going to get is the committee has decided this. And unfortunately, the committee can decide this, but I'm responsible for it. And that is one of the things I think that boards need to be thinking about and that organisations need to be thinking about in advance. How do you deal with that tension? And unfortunately, if the result of that tension is that the committee says, we're still stuck with this, we're going to keep everything under legal privilege, we're not going to go to the regulator, we're going to carry on selling this product, it brings us in X, Y, Z, and I'm afraid, as the senior manager, I am going to be left with little choice other than to go to the regulator. And that, I think, is a very, very difficult position for people to be in. Because, of course, at the same time, they owe, personal relationships with these people who are on the committee. They've been part of the business. They're at a senior level. But at the end of the day, do you want to be the person who's being investigated? So, as I say, post-Green, pre-Green, we had a situation where it may well be that there was a lack of a methodical approach to deciding who should be investigated. Post-Green, that will not happen. And, there will be a record of why you're in or why you're out. And the big thing with an investigation, the most important thing with an investigation, is to try to ensure that you're out. Because if you are in, then it is a long and painful process. And, typical investigation, requirement to produce documents, requirements to attend interview and answer questions. Every investigation, by definition, is approached with the benefit of hindsight. And it's approached with the benefit of hindsight in the sense of, something went wrong, let's find the reason. Rather than, and the FCA, is very careful about, and tries to be careful about this, tries to keep an open mind, and the words that Mark Stewart has been coming out with give comfort to this, but it is very, very difficult for any investigator to actually approach it, to build up the facts without starting at what went wrong. So it's always going to be viewed through the prism of what went wrong. And of course, you as a senior manager will need to establish what you knew at the time. And that's quite difficult. And you'll need to say, well, what I did was reasonable based on what I knew at the time. And if you haven't got any pre-planning for this, that's going to be quite difficult, unless you happen to, be in the position where you are a regulatory expert and you've gone through this before. What information were you acting on? Where's your record of what you did? And of course, as I've mentioned before, and picking up Francis's point about the committee, there is going to be finger pointing. Everybody's going to be pointing the finger at everybody else. What does that lead to? Picking up again Francis's point, it leads to the possibility that the firm's interests diverge from the senior manager. And that is a really difficult issue, because in terms of the firm, in terms of dealing with the FCA, dealing with the regulator, firms want to settle, they want to take a discount for early settlement, and they want to move on. And they want to protect their regulatory relationship. Your ongoing position as a senior manager while you're being investigated, well, very difficult for you to continue. Very difficult for the firm to allow you to continue, because the firm has a duty to ensure that you're fit and proper. And to be honest, if something serious occurred on your watch, then that's going to be quite difficult. Potential employment action by the firm. We're not going to go into that today, but I have seen that in a number of cases. And the time frame. Well, investigation, 18 months to 2 years. Internal decision-making process within the regulator, 6 to 9 months. Tribunal process, another 2 years. So you're probably talking about something like 4.5 years from the event. And at the end of the day, you can get fined, you can get public censure, you can get your approval withdrawn, you can get prohibited. There will be massive legal costs. Luckily, Francis will be able to come on to the discussion of how those legal costs are met. But there may also be a financial penalty. And there is no way that a firm can pay your financial penalty for you. So this is a very significant issue for any senior manager. And I think, the point that I would make just very quickly is firms should be thinking about how are they going to deal with this if and when it happens. Francis.
Thanks, Peter. Okay, well, let's shift the mood a bit to protections. Until now, there have only been 2 forms of protection available to you. There is a third, which we'll come on to talk about. But these 2, directors and officers insurance and the company indemnity, are both extremely important. And they're important in this context, as Peter and I, mainly Peter, has been making clear to you. What this is about is an equivalent of firepower. The regulator has virtually infinite resources. Those of your employer are also likely to be significant. What you will need access to is firepower to protect you and your reputation should there be a problem. And so it's really important to have an understanding both of the good points, the strengths of D&O insurance and indemnity, and the weaknesses. And at the end of this slide deck, there are indeed 10 questions designed to give you the basis for going into the subject in a little more detail with your advisors. But here, if you'll allow me, just a 5-minute plus 30,000 feet helicopter view of D&O insurance first on a good, bad and ugly basis. And let's start with the good. The good news on D&O insurance is that it should cover you for all of your defence and investigation costs once you are embroiled in the sort of investigation difficulties that Peter's been highlighting, subject to the terms and conditions of the policy. And the good thing also about the D&O insurance is that it's a source of indemnity independent from the company. What you need to understand and know about D&O insurance is, however, that it works on a claims-made basis. What this means is it only responds to claims made against you in the policy year in which the claim or investigation is made. So if you are responsible for regulatory breach in year 1, but the regulator doesn't come knocking on your door until year 4, it's only the policy that's in force in year 4 that matters, not the fact that you had cover when you were responsible for the regulatory breach. The second key point in D&O insurance is that whereas you will get cover for formal investigations in which you are the target, and indeed some policies provide cover beyond that, what they won't cover you for is the sort of steady state, as Peter described it, the business as usual dealings with the regulators, because what hasn't properly been appreciated is the extent to which the business as usual dealings with the regulators have really changed, such that the position and potential liabilities of the senior managers at that stage before enforcement is involved is absolutely critical to your ability to avoid censure and penalties at the end of a painful regulatory process. D&O insurance will simply not kick in unless there is some kind of investigation. It won't do the business as usual interface between you and the regulator. The terms are often complex. They run to 50 or so pages. Not all policies necessarily need to be that complex, but they're not that easy to navigate one's way through. And I was struck by the fact that in the polling question, no one said that they were very confident that they knew how they were protected either by D&O insurance or indeed the company indemnity. The shared aggregate limit point is also important. D&O insurance is really a misnomer. Yes, it covers directors and officers, but it also tends to cover all employees in an organization or all employees in a managerial supervisory capacity. In a large company, that could be very many. And it also, and this often isn't also understood, it covers the company itself to the extent the company indemnifies the individuals. It can claim the money back from the D&O insurers. So asking how big the limit is should perhaps be preceded by a prior question, who is my limit shared with? The ugly side is that whereas your position may be quite clear-cut and you just want confirmation from the D&O insurers that your legal costs will be paid, from the point of view of the D&O insurers, the landscape may look very much more complex with multiple claims coming in from different directions, resulting in complex reservation of rights letters being written, which will need translating by your own lawyers and leave you feeling, perhaps even if you are having your costs paid, that it won't necessarily always end in the way that you would wish it to end, and that those costs indeed can be clawed back in certain situations. So moving on now to the company indemnity, and starting perhaps here with the bad, because the key point to make about this is surprising how often I need to make it. There is no right under English law to an indemnity from the company to you as a senior manager or any other form of employee at all. It is all permissive. So the Companies Act allows the company to indemnify you, but everything is to play for in the terms of that contractual agreement. And I've seen a huge variety of different forms of indemnity offered to senior managers, ranging from terms which make the indemnity conditional on an unsuccessful claim under the D&O policy, to indemnities that only cover you for costs in action, claims, or proceedings. Well, if there's an action, claim, or proceeding, it may already be too late in the way that Peter and I have been outlining it, because you may need access to independent legal advice before there is a claim, action, or proceeding. Even if your indemnity does allow that, I would venture to suggest that in most, if not all cases, that concession by the company to allow you access to independent legal advice is almost always given at the company's own discretion. And indeed, the company's discretion can be exercised against you, even in situations where you are theoretically entitled to an indemnity. I've certainly seen situations where, even though there seems to be a contractual right to the indemnity, by reference to the toxicity of the allegations which you face, perhaps as a former director, because you parted company
from your employer. They're simply not willing to honour that indemnity in the absence of a court order requiring them to do so. Solvency risk, plainly if the company isn't around, then it can't indemnify you. There are many good things about company indemnity, don't get me wrong. Unlike D&O insurance, it's not capped, it's not annually renewable, and unlike D&O insurance, which could be a good thing, there are fewer terms and conditions. You just need to make sure if you're the senior manager that you've got the right ones there.
Can I just, Francis, can I just ask you a couple of questions on that? I think one thing I'd like to make clear is that in terms of regulatory fines, the company may not indemnify you, and you cannot obtain D&O insurance for that. What you can get an indemnity for and get D&O insurance for are the costs of dealing with an investigation. I think that's right, isn't it?
I think that's absolutely 100% right. It's only the defence costs, fines and penalties, absolutely not insurable. So when I talked about equivalence of firepower, it was in the context of legal representation. Absolutely right.
And then the second question I was going to ask was, if I was a senior manager within the firm and then I've left, and it's 3 years since these events, and the regulator is now looking at them, how am I going to be covered by D&O insurance?
So the key point you need to bear in mind at the point at which you leave is to seek appropriate insurances from your soon-to-be former employer. And you need to seek those reassurances in the form as tightly as you can, to the effect that the employer will continue to buy D&O insurance into the future on the basis of the claims-made principle that I outlined. Obviously, no employer can guarantee that they will buy D&O insurance into the future, but that's your first port of call. Your second port of call is to look at the policy in the year in which you retire, and I use those words parenthetically in inverted commas, because the word retirement is often subject to definition in the D&O policy. Does it mean retire from the industry, retire from that organisation, retire in that post? The benefit to you of a retirement, as the D&O insurers understand it, in the policy year in which you do it, is that provided you come within their definition of retirement, you may, in the event that the company doesn't buy D&O insurance into the future, benefit from such limit as exists under the policy in the year in which you retire. But that cover is normally not given in situations where the individual goes on to another post in another organisation, in which case your only option is to consider buying your own insurance.
So it's very important when you're leaving an organisation to check what the D&O position is.
It is very important. Can I just go on in the few minutes that remain to talk about a third and complementary means of protecting yourself in the sort of steady state area that Peter was talking about in the earlier section of this webcast. In February of this year, we launched a pure legal expenses policy that is designed to sit complementary to D&O insurance. It's not a substitute in any way, shape or form to D&O insurance, but it is intended as a supplement, and it kicks in at an earlier point to any D&O insurance, he says bravely, but I think this is a claim I can make, because it's triggered by the senior manager's own subjective assessment of the need for access to independent legal advice consequent on any request for information, advice or assistance from a regulator. So going back to our example, where the regulator writes a letter saying, we'd like you to look at issue X in your organisation, that would be enough to trigger this policy and allow you access to independent legal advice. The way the policy works, and it can only be bought by the organisation on your behalf, is that if you have that subjective assessment that you do need access to independent legal advice, then you should go to the company's general counsel and make that case to the general counsel. If the general counsel is persuaded that yes, this is an appropriate case for you to get independent legal advice, then off you go, and you can go either to a panel, a pre-selected panel, or indeed to a lawyer of your own choice, or the GC's choice. Should you go to the GC and the GC say, no, we're not satisfied that you need access to independent legal advice, or should in the rare situation you feel uncomfortable about even going to the GC, then you can still access independent legal advice, but in that event, you have to pay the first, it's up for negotiation, but something in the region of £5,000 out of your own pocket to avoid situations, both to the discomfort of the insurers, but more importantly to the discomfort of the organisation who's buying this policy on your behalf, that you will go off at the drop of a hat and get independent legal advice where it isn't needed. It is there to cater for the situations that Peter was outlining, where there is a real problem and there are really difficult issues to sort out, to allow you to navigate the thicket of your duties vis-à-vis the regulator and your duties vis-à-vis your employer, and ensuring that you get a good result through the two. That's an overview of what this LEAP policy does. It works on the basis of each senior manager getting a modest ring-fence limit, maybe £250,000, £500,000 of their own that they can spend up to the point at which the D&O policy is triggered by a formal investigation. At that point, the policy stops paying, but it allows you to have the balance of that money available to you in the event that the D&O insurance ultimately gets exhausted. And it is, importantly, picking up Peter's question to me earlier, it's available to you after you leave the company for a period of 6 years, provided you ensure at the point at which you leave that you exercise your option to buy the cover in that way. So you have the sleep easy reassurance that in the event someone does come knocking on the door, you have either hopefully your D&O insurance and or at least this additional protection in the form of access to independent legal advice.
So, Philip, do you want to hand out some questions now in the time that remains? How do you want to play?
Yeah, a couple of questions that you both have addressed, but I'll go through them very quickly. We've only got a few minutes left. I am covered by D&O insurance if I have left the firm at the point the investigation has started.
That's right, provided, and there's a big proviso here, provided that the investigation has started in a way that allows that investigation to attach to the policy in the year in which you leave. So you're quite right that if it's a formal investigation, it almost certainly will have triggered the D&O policy, and that anything relating to that ought to be covered and protect you well into the future. The difficulty arises if the investigation hasn't been notified to the insurers, and sometimes there is a time lag in these situations, and it may be that the policy goes through a renewal phase between the point at which you retire and the point at which your employer sees it fit to tell the insurer about this investigation. In that event, you may not have the reassurance unless you specifically sought it from your employer that this has been notified, so that your protection is attached and hardwired into the policy.
Okay. Another question. Can you really insure against a settlement where this is a regulatory fine? Surely that challenges the creditable deterrent of the fine itself.
As Peter rightly pointed out, absolutely not. Neither the LEAP policy, which is a pure legal expenses policy, nor a D&O policy that purports to cover your claims and damages, and settlements indeed, neither of these, nor indeed any insurance policy, would cover you in respect of the fines and penalties. It's simply not possible because there's a legal prohibition under English law in that respect. That isn't necessarily the case in other foreign jurisdictions, but it is the case here in the UK.
Okay. One for both of you. Do you expect to see an increase in the regulator seeking attestations to identify issues, seek assurances from senior managers?
I anticipate that attestations will continue to be used. I think that attestations may well be used for certified individuals. I think that the position with senior managers is that this regime means that the attestations are not really as important anymore because the FCA is able to identify the person who is responsible. And they are able, and I think in one of their consultation papers talking about the background to this, they said, we want this and we want the identification of responsibility so that we know who we can go and ask questions of, and we also know who to go and talk to when something has gone wrong. So, there's a clear identified responsibility. Obviously, attestations will continue to be used, and as today, before anybody signs an attestation, they should go through that, analysis to satisfy themselves that they're happy that what they are signing to is something which is accurate.
And I've heard the view expressed that indeed under this new regime, basically all these touch points with the regulator, the letters that they write, are effectively attestation, requests for attestation for all practical purposes. Because if you're responding to a letter saying no, there isn't this problem, whether it's called an attestation or not, under this regime, it effectively amounts to much the same thing.
Absolutely.
Okay. Another question. Would reputational concerns be of consideration to the FCA to the extent that they may impact financial stability in the UK?
There is a provision within the Act which would require the FCA to speak to the PRA in the event that there is something which could potentially upset financial stability. But we are talking there about the highest impact actions, and I think those are few and far between, and I don't think that anybody should be thinking that is a potential safety blanket for them as a senior manager, or indeed as a firm. And I think one of the things that we have to recognise is that the regulators have toughened up their view as to what is the responsibility of the state and the regulator, and what's the responsibility of the firm. Nobody thought Lehman's could go down.
Exactly. Question for you, Francis. Are you saying that I have to do everything myself? Can't I rely on people who I've delegated to? Help is the question, I think, there.
I assume that question's in the context of the senior manager regime rather than how to buy my insurance. So treating it in that way, absolutely, you are fully entitled and indeed expected to delegate, but what you cannot delegate, and what the courts have repeatedly made clear you cannot delegate, is your duty of oversight, is your responsibility to supervise. And that is true as much under the common law duties as indeed under the regulatory framework. The difference with the regulatory framework is you may have less comfort that the regulators will look at you without the benefit of hindsight, whereas with the court you would hope that in discharging your duty of oversight and delegating appropriately, they would only look at the facts as they were at the time, or as you could reasonably have understood them.
Okay, and can't my D&O insurance provide me with all the protections I need?
It can provide you with all the protections you need, and should indeed do so in the context of a claim or investigation. What it won't do is trigger at a very early stage. As a thought to make clear, the D&O insurance industry growth generalization, but it is true, they do not regard it as their responsibility to cover you for your business as usual dealings with the regulators. They make the point that the premiums for D&O insurance will look very different if they were covering you for that sort of stuff.
And so, gentlemen, in summary, what's the peace of mind, what's the offering on the table that senior managers listening into this webinar can go forward with? Is it literally looking through the rear-view mirror of their car, watching where the regulator is coming from, or do they have clear line of sight and understanding and confidence for themselves as well as the firm in their insurance, in potential elite products, and also their understanding of what reasonable steps is?
If I may answer, I think that this is a time when people should be thinking about how would they plan for the difficulty of dealing with an emerging issue. And I think that firms should be thinking about what is the approach that we would take, who are the people who have got the expertise to do that, and how will they interact with the senior manager who has responsibility, how will reporting take place, how will we manage that tension which could potentially arise between the firm and the individual, because it absolutely has to be the case that planning now will mean a lot less pain and confusion when a problem does occur. And when the problem does occur, everything that is done is going to be poured over by the regulator. So that would be my advice. Plan at the moment.
And all I'd add to that is just make sure you know where your running shoes are, but also make sure that you know that they fit.
Thank you very much, Peter. Thank you, Francis. And we are going to socialise the slide deck as we promised at the start of this webinar. We're also going to diarise some dates because I think these are two key issues that we're going to unpack early next year, in a couple of breakfast workshops and breakfast briefings that I think will be beneficial to the literally hundreds of people who have dialed into this webinar today. Thank you very much for your time today, Francis and Peter, and have a good day, everyone, on this webinar. Thank you.